If you own a property and have a second mortgage on it, and if you want to keep this property and get rid of the second loan, attorney Shaw Parali can help. Call 510-742-5887. Due to the uncertain economy, many people have settled their debts for a fraction of its value. It's recommended to use an experienced lawyer to deal with it. Shaw Parali is an experienced debt settlement attorney and has handled hundreds of such cases successfully. There are no upfront fees for debt settlement. Only when you win, you pay. Call Shaw Parali, attorney at law, at 510-742-5887 or visit yourdebtsettlementattorney.com for a free assessment. This is just an advertisement. No attorney-client relationship is established by this ad. The law does not guarantee success. Call 510-742-5887.
And now, from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shaw Parali for the Shaw Parali Law Show, coming at you with over 50,000 watts of power. The Shaw Parali Law Show, where all your views matter.
Hello everybody. Assalamu alaikum, Sastikal, Namaskar to all the listeners. This is Attorney Shaw Parali. Hopefully today we'll be able to keep the show live. It's June 1st, 2017, and we are going to discuss about immigration. Of course, we will be opening the line in a few minutes. The number to the studio is 408-912-5565, and today I have Franco on the board with me. Thank you, Franco, for being here. And now we are going to discuss, of course, about debt settlement and immigration. And anything I'm going to tell you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And just to let you know, today first of all, I didn't have a chance to say Ramadan Mubarak to everybody. It's Ramadan and it's the month of sacrifice, and I hope the world will be becoming a better place for good people to be in there and think about the poor and also to share. And the fasting is a very big month for us Muslim, and I thank all the supporters for that. So now we're going to discuss, of course, a lot of things happening in immigration. For one, we have this decision that came basically from the USCIS adopting what happens on the H1B cap exam, master's cap, pretty much. The master's cap is a part that is kind of really affecting a lot of people. The policy memo that now adopted the matter of A-T. A-T. I know whenever you do an appeal with the USCIS to the Immigration Board of Appeal, sometimes those decisions become, I'm sorry, we're breaking a little bit, but I hope this will get better. Those decisions can be adopted as a memorandum, which makes it pretty much the guideline of USCIS. Although if you look at the memo, they have not really kind of taken this to a level. They basically say it's not to be used, but the truth is that it is going to be used, unfortunately. So what this memo basically adopting the Administrative Appeal Office decision is about, excuse me, it's about the degree itself. Where is your degree? How did you earn the degree, etc. And I apologize, I've been running a little bit quickly to get on the show, so I am kind of a little bit out of breath, so I apologize for that. So just to let you know, we are covering the topic of H1B cap exemption, especially the master's cap. And this decision pretty much now made clear something, and we have been saying for a while. And one of the decision, of course, is the school has to be accredited at the time when you graduate to benefit from the master's cap. But also, the school has to be either in a process of accreditation. But if the school had no potential of accreditation, then you cannot benefit. what happens next? How this is going to affect people? I'm going to take the caller in a minute, Franco. But how does it affect people? Well, it will affect for future application, but it also can affect people who have filed before under the master's cap and Garvin. Then they can kind of question those master's cap and basically revoke the H1B. We've seen this before, and now there is a chance with this decision it will become worse. So I will post that decision on our website soon and a link on our YouTube video after the show. So please check it. It's the matter of A-T Inc. Let me take a caller, Franco. This is Shapra. You're live in here.
Oh, hi, Shah. Good morning.
Good morning, sir.
Hey, just quick question. If a H4 person has a full visa, they can start a business or they can work. So if, let's say, for example, if they start a business, open business, and can they hire their partner, their spouse, who is on H1 on their business to work?
No, technically no, because what this does, it's self-serving. So basically, the H1 has to be independent, because if you're putting the H1 on that business, it is possible if there's a big board on the business where the decision is not made by your spouse, then yeah, there's a chance it will go through. But otherwise, it's not recommended, and I'm pretty sure they won't approve it.
Okay, so can the H1 spouse have two H1s at the same time? Okay, they can work their one employer and they can work another H1 for their spouse who is on H4. Can it happen?
Well, they can have two H1Bs. I don't know for the spouse business. That have not been tested, so I don't know if it will work. Although everybody's saying, which are people who know a little bit about H4, are not recommending to do that. But two H1Bs possible. It's called concurrent H1Bs. A lot of people working on part-time basis do concurrent H1Bs. Those are allowed. But having your spouse on the H4 and then working in that same business might create some conflict. So I have not tested it, but it might be possible, but I doubt they will accept it because it's kind of self-serving. Okay?
Okay, just one other question, quick one. Let's say H1 person, spouse, changes the job, moves to the different employer. Is there any paperwork to be done for the H4 spouse?
Yes. You have to also file an extension for the H4, because the reason for that, if the company A, for example, cancel the H1B, the H4 gets canceled and the EAD will go away too. So I recommend, and it's important, it's mandatory almost. Whenever you are doing a transfer also H4. Although it's not called a transfer, it's an extension of H4. So anytime you move to another company, make sure that they file the H4 together. Okay?
And how the things are looking for H4 in coming future?
So far, it looks good, unless we have this problem going on right now with the lawsuit. But apart from that, I don't think Trump is really focusing on it. So let's cross our fingers and keep it. It means a lot to keep the H4 for me, because I fought so much for it. But I'm hoping it will stay. Okay?
Okay, thank you very much. I appreciate it.
Good luck to you. You're welcome. Let me take another caller. This is Shara. You're live in here.
Hi, Shad. I have a quick question.
Yes.
USCIS came up with a rule saying that computer programmer with level 1 salary is not considered as a specialized occupation. But this came on after April 1st when the applications were filed. So what happens to the case where the applications were already filed with this level 1 salary and computer programmer's title?
Yeah, that's the $10 million question. Okay, this is how they did it. They played very smart. They issued the memo on, I think it was March 31st or something in the afternoon on a Friday, and it became effective on April 3rd, where most people have already mailed their package of H1B, okay? But unfortunately, I'm already seeing it. They are denying those cases. So not even level 1, even level 2, they are giving a hard time. So unless there will be some lawsuit kind of challenging that as a what we call ex post facto law, that means a law that was passed after, because they were very smart the way it was done. It was Friday afternoon. If you look at the memo, it came on, I think, on March 30th or something. But since it was a weekend, it got published really on April 3rd, which was Monday. So we don't know yet unless someone challenge it, but unfortunately it seems like they are blanket denying those cases.
Oh, okay.
Okay, but
Okay.
let's hope someone will challenge it, and if there's a good challenge in court, we might see a reversal, but that might take some time. Okay.
Or else would they
Okay.
give us a chance to refile the LCA or something like that? Or can that happen or no?
No, that will not happen unless the court orders them to do that. But this is very, very kind of how to put it, very unfair from there. It's
Yeah.
capricious almost the way they did it, because they knew everybody would mail everything on Saturday, which most lawyers did also. And what happened is that that thing just appeared suddenly on Monday. It was already too late. So let's see if there will be some fight against it. I have not had any cases personally where we file on that, so I cannot fight those. But hopefully, if this comes up, that will be my argument that this is almost an ex post facto law, which basically the
Okay.
law and everybody mailed it. That will be the argument. I hope lawyers will take. And we need to check with the American Immigration Lawyers Association. Once they start issuing denials, then we will be able to fight this. Okay. Okay.
Okay. Yeah. Thank you.
Okay. Good luck to you. Let me take another caller, Franco. This is Sharp Radio Live in air.
Yeah, hi, Shah. This is Kumar. Thanks for taking my call.
Kumar. You're welcome.
Hi, I have a question regarding my brother. Actually, he and his wife already is in India for a short trip, and my brother is going, planning for a visit to India. He's not been to India for 10 years almost. So his wife is already in India. So when this guy goes, she is going for stamping next week. So if her stamping is done, everything is fine, she'll come back. But when my brother goes and his visa is like for some reason, like for administrative work, 221G or any other reason, if his visa takes time, then can his wife stay in US? Is that okay?
Okay, this is the thing. The wife is good for H4 stamping, right?
Yeah, H4, yes.
Yeah. So the wife already got H4?
Say again, I'm sorry.
Did the wife get the H4?
Yeah. She's going for H4 next week.
Okay. Well, technically, if there's a problem, even the H4 will be put under administrative processing. But if they block his H4 and the wife is on his H1 and the wife is on H4 here, technically, depending what is the reason they block him on, if the H1 gets cut off under the 221G, which is the administrative processing rule, then the H4 will get cut off also. But if it doesn't get cut off, it's just they want more documents, then she will be able to stay because the H1 is still good. But most of the time, if they're already going to question if they're planning to question the husband's H1, then the H4 will probably get blocked too.
No, she is going to India every other year actually. So she is current, like she'll be visiting India often. But my brother, it's been a long time.
Yeah, the only problem is that his wife H4 will be dependent on your brother. It doesn't matter how many times she travels. At the end of the day, it's the H1 that holds the H4. So if the H1 have issues, then the H4 should have issues, unfortunately. So
okay. So do you suggest better both go together for H4 and H1? Will that be good?
Yeah, that would be the better way. But unfortunately, in it's hard for me to analyze. Before you leave, just give me a call. We'll do a consultation, and then before making any move. So we don't want anybody to have in trouble. Give me a call at the office, 510-742-5887. Okay?
Okay, sure. I'll call you. Thanks, Shah.
Thank you. I apologize again for the sound, ladies and gentlemen. We still have some technical issues because I'm doing remote shows. So let me take another caller, Franco, and let me know about the sound. This is Shapra. You're live on air.
Hello, Mr. Shah. I have a quick question.
Yes.
So when I'm actually planning to go to India in around December, And on the way back, I was planning to stop in Dubai for 3-4 days for just visiting. Do you think that would be a problem in the given circumstances?
Not necessarily. It's not where you stop. It's coming back that is becoming a problem, especially if you're working for a company that is basically doesn't have a good reputation or have some issues with USCIS. If your company is good, your case is good, you can travel. You're fine. You can come back easily.
Yeah,
But
but there is some
stopping
ban
somewhere
on
when
travel, right? So that's why I was thinking, particularly for Dubai, would that be a problem?
no, there's no ban in Dubai. Dubai is a
Yeah,
transit port. It's
okay. Okay, so you think that it should be okay, right?
Yeah, even the bans are not there because the court blocked them. So it's not Dubai is not really considered Middle East actually.
Right.
Dubai is almost like a Europe, so they don't really worry because Dubai pretty much do all the quote unquote dirty work there. So they don't really kind of they do all the checking already there for USCIS, so that they don't have to
Right.
do the work here. So I mean for the CBP. So you can get blocked in Dubai, yes, because they already have all the checking by CBP is already done actually in Dubai. So that, yeah, but Dubai itself is not going to cause you to any problem, okay? It's
Okay,
your case
so
itself.
it's
If your
just
case is
my
weak,
record
then
and the company that I work for has to have a good record, right?
yeah, the company has to have a good record and you have to have a good record. If both are good, you should be able to come back, okay?
Okay, sounds good. Thank you.
Okay, good luck to you. So let me take another call. This is Shapra. You are live in air.
Hi, Shah.
Hello.
This is Deepak calling from Fremont. Thanks for taking my call.
You're welcome, Deepak. How are you?
I'm good, thank you. And how about you?
I'm doing okay. I'm so sorry for the sound, but you can hear me. Let's go ahead. Let's talk. Go ahead.
Yes. I have a question regarding H4 EAD. Is it okay to travel when H4 EAD is under process? It's under processing, and it's a standalone H4 EAD application.
Okay. Yes and no. It all depends what you're calling H4 EAD. If you're doing an H4 change of status plus the EAD, then no, don't travel. But if you file only the EAD, you are already an H4, then yes, you can travel, although it's not recommended to travel. Okay? There are two kinds.
Okay,
are you moving to H4 already on H4? Oh, you got it. Okay, great.
It's a standalone H4, so it's okay. And I have a follow-up question regarding H1. I have an H1B extension which is approved, and it will start from this September. And can I transfer my H1B before September? And what happens to the extension once I transfer it to a new employer?
Okay, is it a new H1B this year cap, or is it
no,
you already had?
It's an H1B extension. So
yeah, you can transfer, but make sure that. But the original H1B is already expired, or it's still there. The dates are still there.
It's still, the date is still there.
Okay.
The question is the new H1 extension that I received that is approved. It's starting in September.
Okay.
So I want to transfer
perfect.
before September. So what happens to the new one?
Okay. Yeah, that's fine because when you transfer, they will give you a new extension attached to it. So you're fine as long as you transfer because both is approved for you, so you don't have this problem. But the second one was pending. Once the first one gets off, you cannot really transfer. You have to wait for the extension to be approved. But since it is up to September in your case, you can safely transfer, and you don't have to worry about the other extension because when you transfer, you will get a new extension attached to it. Okay?
Okay, got it. Thanks again. Thanks for taking my call.
Good luck to you. Let me take another caller, Franco. I know the sound is not great, but I'll continue as much as we can. This is Shapra. You are live in air.
Hi.
Hello.
Thanks for taking the call.
Hi. Yeah, welcome.
I have a question regarding job transfer. So I'm on H1B, and if I move jobs right now, given that premium processing is not available, how do you start work? I guess you can start work just on the receipt of H1B notice, but how risky it is to do that?
Okay, that's a very, very, very good question because I get that pretty much on a daily basis. Well, it is risky depending on the company, the lawyer, etc. So you can try if you are in a solid status, you are doing a transfer under AC21, I think section 105B, if I'm not mistaken. You are eligible to start working the day you get the receipt. In fact, you are eligible to start working the day you mail the package and it's received by USCIS. So, having said that, now the problem becomes if there are any mistakes on the case, then and if company A, for example, cancel your H1B, you won't be able to move back to company A unless you refile a new H1B, etc. So that's the risk. So the risk is basically based on the company's strength, the lawyer's strength of preparing the case, etc. So most people are doing it because they don't have a choice. But if you have a choice, I'm recommending people to wait for an approval, then move.
Okay, thank you. And then just one follow-up question. So I also have, my I-140 approved. It's been approved for 2-3 years, right? Now, if I move and my current company where I work, through which my I-140 is approved, if that company, say, gets bought by another company and basically there is no legal existence of that company anymore when I move, and then when my I-140 gets filed with the new company, they will ask to port the priority date, but there is no existence of my old company. Does it matter?
It doesn't matter because the original I-140, when it was filed, was a genuine company, because the priority date will stay. It doesn't go away just because the company goes away. Because the priority date is like a line in the queue. It's a number in a queue. So as long as the I-140 was filed genuinely, that means no misrepresentation or fraud, you can keep that priority date. So it's not a problem.
And even if the job description changes, you still hold your priority date?
Yes. In fact, job description has nothing to do with priority date. So, for example, let's say you file under programmer analyst, right, and you got an I-140 approved. Let's say down the road you get another company and you got experience, they put you as engineering manager, you can still borrow that priority date because that priority date belongs to you. Okay?
Okay. Thank you very much. Really appreciate it.
Good luck to you. You're welcome. Let me take another caller, Franco. This is Chaparral. You're live on air.
Hey, Shah. Thanks for taking my call. I have a quick question regarding.
Yes, I'm listening.
So, in December 2016, in November 2016, I changed my employer. I'm on H1B. And after that, in December, I traveled to India and I came back, but I didn't got the new stamping on my passport because that was still valid until until September 2018. And I haven't filed anything separately for H4. That's for my wife. I just heard you mentioning on the
So did your wife travel with you? I'm sorry.
Yes.
Hello?
Yeah, she did travel with me in December.
She did travel with you, and when she came back, they gave her an I-94 with the new H1B that you had.
No, I don't think so because the validity is still with the same as the old employer.
Well, the problem is the old employer has canceled the H1B. Sometimes they don't cancel it when you transfer.
I think they already did it. I checked it. They already did it. They canceled it.
Okay. And when did this happen, you said? In November?
Yeah, November last year. So November, I got the...
Okay.
Yes, in December.
Okay, so you need to quickly have her travel again, come back on H4. Does she have an H4 stamp on her passport?
Yeah. And she even got a new I-94 after changing the employer because she also traveled to India and she returned back in December. By that time when she returned, the old H1 was already cancelled.
Okay, then she's fine then. Because by you returning, you reset it. She reset it to the new H4. What I was talking about here are people who don't travel outside. Because what you did by her traveling after the H1 was cancelled, her H4 attached automatically to your new H1. Had you not traveled, it would have... So in your case, she's fine now. Okay.
But there's one slight issue. My I-94 is valid until December 2018, but hers is valid only till September.
For her in September. Yeah, it's only a 2-month difference, right? 2 months difference. How many?
Is there anything that I should do for getting her extension for like September until December?
Yeah, you need to file an H4 extension for her now because it's already less than 6 months before it expires, unless she's planning to travel again. But since your H1 goes only till December, it will be not worth it. So what you can do is that when you file for your H1 extension, you file also for a H4 extension because you probably will be filing your H1 extension by this month or so. So because your 6 month
my H1
eligibility
is expiring in December 2018, and I already like nearby my 6th year, so there will be no more extension for me now.
Okay, and how about your wife? When is
my
it expiring?
wife,
September.
her visa is valid until September 2018.
Okay, so you have only 2 months. You cannot file anything right now. It's too early. You can only file that 2 month, 6 months before. So next year, around April, you will be able to file that. Okay?
Okay, and is this something that I can only do, or do I need to ask my employer for extension for my wife?
No, you don't need to ask your employer. You can hire your own attorney. You can call us. We can do it for you. No problem. Okay?
Thanks.
Okay.
Thanks for your help.
Okay, good luck to you. You're welcome. And the number to our office is 510-742-5887. Let me take another caller, Franco. This is Chaparral. You're live in here.
Hi, Shah. Good morning.
Good morning.
Thank you for your time to answer our call. I have a quick question regarding the LCA, the code SOC code used within the LCA. I hired in Illinois, and that time it was software developer level 3. But then for short-term project, I was assigned in California. That time they applied LCA amendment as computer programmer level 2. And now the project is getting extended, and there is a cutting year. So because of that, there is no location allowances compensated. And when I noticed that there is a lot of difference between these two roles, where the prevailing wage.
Yes.
So is that a loophole companies use, or how can we handle this kind of things?
Well, you have to shift it. You have to shift it back. If they're filing an extension based on level 2 program analyst, although they have said only level 1 they will attack, quote unquote, I would recommend either putting you on a level 3 or level 4, or ultimately you have to shift position because program analyst is no longer in a specialty occupation under that new memo that was issued on April 3rd. So since in your case you have the ability and the potential to be in a different position, they have to offer you something different so that they can extend it. Otherwise, you're going to get a denial on the extension.
Oh, so the computer programmer is no longer approved as H1B special occupation?
Yes, level 1 and level 2 pretty much no. Level 3 we have not yet got it, but it seems level 3 might be okay. We are not even sure now. So we are recommending people, if they can get another job offer with a position which qualifies them in something different, to take that, and instead of trying to fight this, because they have already made it clear, and that was basically the executive order of Trump that triggered that. Okay?
Okay, sounds great. So software developer level 2 still will be good, right?
No, I didn't say that. I say it might not be good because I'm having a lot of issues, people calling for consultation where they're getting a lot of notice of intent to revoke based on level 2s. So you need to be ready for that. They have not said they will deny it, but they're giving a hard time.
Even for not the computer programmer, software developer?
Well, it all depends on the salary. If the salary is kind of low, yes. So it's very hard to tell because I have to look at which county, etc., to tell you just quickly on a broad spectrum everything will be denied. No, but program analyst is definitely one of them that they are really kind of targeting. So a software developer, I think, is very kind of close to that. So they might give a hard time on this too. But I have not seen any case where the denial on this. But we will know because this memo just came out 1 month ago. So as time unfolds, we will know. But in the meantime, don't take any risk, okay? And if there's any problem, give me a call at the office. If there's any RFE or notice of intent to deny, we'll see what we can do. 510-742-5887, okay?
Okay, sure. Thank you. Thank you.
Good luck to you. So I don't know. We have more callers, ladies and gentlemen, and but you can still call the number to the studio 408-912-5565. And I have Franco on the board with me today, really kind of helping me with all our sound issues. Thank you, Franco. And and also I was covering pretty much that topic of the H1B cap under the Masters cap, which is a big news, the matter of A-T Inc. And this is going to kind of be another problem coming up. So what we are talking about now also is also the other memo, that tricky memo that kind of slide in the middle of the H1B time on April 3rd, and that was really kind of very, very unfair. Not to, I'm really kind of holding my words here because it just came suddenly, and it was what it happened is that it was printed on Friday afternoon and published on the 3rd. By that time, most cases were already sent. So let's see how this is going to be treated and how we can fight this. But in the meantime, before I take the other caller, Franco, I wanted to discuss about another problem. A lot of people are leaving the U.S. because they're worried and things like that, and they have debts on their head, and they want to clean up those debts before they go. We are doing that settlement, and we have been doing it for a while. You can check it. If you have second mortgages, credit cards, we might be able to wipe them out by not using bankruptcy. We don't bankruptcy, we use debt settlement. And you can check the website, yourdebtsettlementattorney.com. We can do it for credit cards, we can do it for second mortgages, and some other debts that you have. We can negotiate those debts, bring them down, and you pay only a certain amount and you're out of it. We have done a lot of those cases and help a lot of people, not only for people who are leaving, but U.S. citizens too. And now it's becoming a lot more for people who are leaving the country because they don't want to have debts on their head. Let me take another caller, Franco. This is Shah Burari. You're live in here.
Hey, Shah, can you hear me?
Yes, I can hear you properly. Go ahead.
Perfect. How are you doing today?
I'm doing well. What can I do for you, sir?
Hey, so I had a quick question. I got my I-797A approval notice last week for my H1B, which starts on October of this year, right? Yes. And I'm currently on the F1 OPT. So since the change of status is approved, I'm planning to travel in July, right, outside the U.S. And the I-797 has that I-94 attached to it, right? And it says that I need to attach it to my current I-94 and give it to probably the airline official on my way out. So I'm not going for the H-1B stamping right now because it's before October. So do I need to give that card to the airline official right now? I travel in July?
That's kind of hard to tell, but technically they will ask you, but at least you can give them a copy and keep it, because even a copy will work. But now we have another problem. Are you in cap gap or full OPT?
No, I'm on the STEM OPT right now.
Oh, you're on STEM. Okay. So yeah, you should be able to come back. You don't have to really give that I-94 because that I-94 will kick in only on October 1st. But you might want to give them a copy just to let them know. But this is another problem. When you come back now at the airport, they might question why you didn't go for H1B stamping instead of coming on the F1. When are you planning to come back?
Just in August. So go in July and come back in August.
Okay. You need to explain there why you didn't go for H1B stamping. Okay. Depending who's the officer at the airport, whenever people travel on OPT, they always give them a hard time. Not always, but many times. So have a letter of employment from your employer. Make sure you carry that with you. And have a letter also from your DSO confirming your OPT and your service. Okay?
Okay, all right. So that could work in that case. And once the I-94 changes after I return, do I need to get in touch with my attorney and make any sorts of amendments with USCIS? Because that number is going to change, right, after I come back?
No, it won't change now because you're coming back on the F1 OPT. Before it was doing that, but now it won't. So you will have the same number on the F1 OPT, which is a DS on your stamp, on your passport. They will use the same and the same service probably. But there is no amendment to be made. as long as you're not on cap gap. So as soon as you come back, it will resume to the change of status on October 1st. So there's nothing really to do, but you might want to inform your DSO when you travel.
All right. Yeah, I'll get in touch with the DSO and let him know. All right. Thanks a lot. Appreciate it. Have a good one.
Good luck to you. Wish you all the best. Let me take another caller. This is Shapara. You're live on air.
Hi, sir. This is Vipul here. I have a question about the family-based immigration.
Go ahead.
Yeah, so I had applied for the green card for my sibling, my sister, and that was done in 2008 and I think 2008, 2009, and then we got a priority date of August 5, 2009 on that one. And then also, I think after a couple of years, we got that approval notice also saying that this has been approved. Now, the question, the one thing that I noticed recently on that I-797 notice of action that we got, that in that one, it says that this is the approval notice and section, it says married son or daughter of U.S. citizen. And that is not true. This seems like they have sectioned this into F3, but it should be in F4. So I was just wondering, it could be some error or something, but how do we...
Yeah, it is an error. You need to contact the USCIS and clarify this and mention that this is not the classification. Send them a letter with a copy of that. So what will happen, unfortunately, they will reprocess the case. It might take 6 months to clear, but you need to clear it because the category is not good. What it will cause is, one, it will cause delay, and number two, you will have problem when you reach the interview for the U.S. consulate. So you need to correct it now. Send a letter to them explaining the situation with a copy of this approval notice. Ask them to give you a good approval notice. And you can, after you send the letter, you call them also and follow up.
Okay, but does it mean that they will kind of put us back in the start of the queue, or still the priority date?
No. Priority date will stay the same. Only thing is that it will take some time for them to reprocess the new approval notice.
Oh, okay.
Okay.
So is there a
but make sure you explain clearly
that I can find online to prepare the letter, or just go and go?
There's no template. Please note that this is the date, and due to an error, this happened, and send the letter. And that's pretty much it. And if you are having issues, you can use a lawyer, but it's not necessary. Just go ahead, send the letter, and if it gets complicated, then you can call us at the office. We can get involved.
Sounds good. Thanks a lot.
Good luck to you.
Really appreciate it.
You're welcome. Thank you, sir. The number to our office, 510-742-5887. And anything I'm telling you today, ladies and gentlemen, is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Since I don't have more callers, and I know we got a lot today, I wanted to thank you for listening to the show and apologize also for the sound. I'm going to cover a little bit the topic of debt settlement because this is becoming also a major, because things are not really as rosy. I'm kind of eating my words here. Rosy as it was during Obama time. Things are getting really tough out there. Unfortunately, some people are not understanding what is really happening, and some of them will even call me and say, hey, what happened when I did this for years and never had problems? Why am I having problem now? Well, now things are very, very different. They are really going deep into every case, and you see all those memos coming out, all those executive orders pretty much targeting H1Bs. It seems like the new administration is spending more time targeting legal immigration than unlawful immigration. So anyway, both are wrong. So the thing is now we need to be able to kind of tackle those cases with law and fight them. And unfortunately, not every case is going to be a win. So people have to bear a little bit and be patient. Cases are taking longer. However, having said that, we are getting a lot of approvals too. We just got a very nice approval yesterday on a U visa case green card. We got a bunch of EB1As approved. So if you have EB1 cases, please give us a call, or national interest waiver. These are excellent cases because even though there's a backlog, you still are okay to file the adjustment of status. So look into those, and if you need help, give us a call at 510-742-5887, and the website to check is attorneyonair.com, or piralilaw.com. Let me take another caller, please. This is Shapra. You're live in here.
Hi, Shah. I have a quick question on visitor visa.
Yes, sir. Go ahead.
Yeah. So my in-laws are planning to come here during July and stay here until August, end of August. And the next year, sometime in Jan, they want to come here and stay for like 6 months. So will there be any issue if they come now for like 2 months and then again in January?
Unfortunately, there's no way to answer this because the problem that you're facing is it depends on the officer at the airport. If the officer sees it as a normal, they're coming to visit without any issue, they won't give them a hard time. When it comes to visitor visa, it all depends on the officer at the airport. So technically, no, but in reality, if the officer is not really satisfied or is not in a good mood, they can deny them entry, yes. So you need to be ready for, it's not only for them, it's for everybody right now, for pretty much all those visas. So I recommend that, usually I tell people to leave a space of 6 months to 8 months. In this case, since you're leaving 6 months, approximately, you should be fine. But you should be ready also that they might give them a hard time. So just, unfortunately, there's no way to kind of predict that. Okay?
Okay.
Okay, good luck to you. Okay, so ladies and gentlemen, I don't know if I have more callers, but I will tell callers to give us a call at the office now because Amit is going to join us in 5 minutes. So I wanted to cover the topics of not only debt settlement, but we have 3 things that are very important right now. Number 1 is that new memo that came out pretty much on the H1B Masters cap. And I think, am I still on air? I think I am. So what happens, Masters cap now, if the school is accredited at the time of the Masters is given, you qualify under the Masters cap. And that what this will do, it will pretty much protect you if your H1B was obtained under the Masters cap. Otherwise, it might affect your case down the road. That's one thing. Second thing, of course, this programmer thing, that might be another issue. So we need to pretty much kind of cover on that. And also the other thing that we were covering is debt settlement. And we want to make sure that people understand what is a debt settlement, how it works. If you need help on those, you can give us a call at 510-7425-887. And I think Amit, are you there?
Hey, Saya, I'm here. How are you?
I'm doing okay. So Amit, give me 2 more minutes, and then we will close, and then I'll take you on air. So I was not sure so if the connection was good. So I just wanted to let everybody know that we can help you not only with your immigration matters when it comes to employment-based, company, VAWA petitions, because this is another problem to people getting abused, U visas, EB1A, EB1B, EB1C, national interest waivers, H1Bs, L1 visas. We have done it all. Just check our website, you will see. And for debt settlement, if you need help with credit cards, second mortgages, and other kinds of debts, please give us a call. So I think we have 11 minutes or so to go. I'll let Amit continue with the show, and thank you, ladies and gentlemen, for listening. Anything I told you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And thank you, Franco. We'll be back next Thursday, 10 a.m. again to 11 a.m., and this show will play again on Friday night or pretty much midnight Saturday morning. So please keep listening, and thank you for listening today, and I apologize for the sound. Thank you, and Amit,